The next matter to come before the court this morning is State of Ohio versus Clarence Adams. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve that time, if you let me know when you get started, I'm keeping the clock this morning to keep you apprised of the passage of time. We've read the briefs and we're ready to see where you are.
Thank you, Your Honors. Good morning, Your Honor. My name is Attorney Denise Wilms, and I represent the appellant in this matter, Mr. Clarence Adams. In my time before the court today, I will be addressing and challenging the convictions based on the manifest weight of the evidence, particularly the aggravated robbery in this case. Mr. Adams was convicted of aggravated robbery, and in order to prevail on an aggravated robbery charge, there must be an underlying theft offense. As the court has read from the briefs, there was one eyewitness to this case. His name was Mr. Torres, and he was the only eyewitness here that in his testimony had said that he saw Mr. Adams shuffling and patting the pockets of Mr. Taylor. And, Your Honors, our argument is that several. One is that it was very dark outside. It was approximately 2:30 in the morning, and the testimony revealed that although there were streetlights in the area, the photographs of the area show that the scene was very dark. And further, it shows that the streetlights that were present were across the street from the crime scene. Further, Your Honors, the vantage point that Mr. Torres, the only eyewitness, had was that he was approximately 4 to 5 houses down, and again, late at night. The place where Mr. Taylor's body was located was approximately 10 houses down. Now, the testimony also revealed that Mr. Torres indicated that there was a vehicle that night, that Mr. Torres, Mr. Clarence Adams, Mr. Diaz, and Mike Cuevas had gone to the Dairy Mart store, and prior to going to the Dairy Mart store, that Mr. Diaz borrowed the keys to his grandfather's vehicle. Mr. Diaz was the one who was driving the vehicle. The testimony also showed that earlier in the evening that Mr. Diaz, Mr. Cuevas, and Mr. Adams had gone to a school and had punched some windows out in the school, and Mr. Cuevas, who also testified, had to go leave the group and go clean up his hand. Once Mr. Clarence Adams was stopped by the police, he was also observed to have cuts on his hand that were inconsistent with going through bushes, which is what he had told the officer. The officer felt that they were larger cuts. Our argument is that they were more consistent with that of Mike Cuevas and that of punching in the windows at the school, which would lead to Mr. Adams' blood being located in the vehicle of Mr. Diaz, or Mr. Diaz's grandfather. When Mr. Torres left the scene, he had indicated that he saw Mr. Adams and Mr. Diaz run up to a gentleman and start hitting on the gentleman and kicking the gentleman. He then ran from the scene. When he told officers that the car that they were in, after they got back from the Dairy Mart, they had parked in a driveway across the street from Mr. Diaz's residence. His name was David Ortiz. When he left the scene, he said that the car was located in the driveway. There is conflicting evidence, Your Honors, that says that Michael Cuevas, the one who had left the scene earlier to go wash his hand, had testified that the vehicle was actually in the street. It was not in David Ortiz's driveway, as Mr. Torres, the only eyewitness, had indicated. In addition, at trial, the defense attorney had brought up the fact that Mr. Torres had no eye exam in a couple of years, arguing that in addition to the dark lighting, that he also may have had some issues with his eyesight. In addition, he testified that he was under the influence of alcohol and drugs that night. And he was also biased because upon him arriving to the group that night, they were in the garage waiting for Mr. Diaz to obtain the car keys from his grandfather. Upon his arrival, my client, Mr. Adams, grabbed him by the shirt and began yelling at him. And so he was not very happy with my client that night because of that incident.
So is your argument that the fact that he had been grabbed by this individual would cause him to make up this account that he was involved in the murder of this young man?
Well, Your Honor, as the brief indicates, although the prior counsel who wrote this brief argues against the manifest weight of the evidence for the convictions, it says in the title, most of the argument, Your Honors, are the argument of the theft. That Mr. Torres, the eyewitness, never once said that he ever saw my client in possession of any of Mr. Taylor's property. The only thing that he states is that he thought he saw him petting down. There is no evidence that he ever removed anything from the pockets of Mr. Taylor, and there was evidence that was located in Mr. Diaz's vehicle, and that evidence is there was the victim, Mr. Taylor, his wallet was found in Mr. Diaz's vehicle. His cell phone was found in Mr. Diaz's vehicle. His clothing was found in Mr. Diaz's vehicle, as well as a glove. Mr. Taylor's watch, the victim, was also found in a hoodie that Mr. Diaz had left at Michael Cuevas' house. So after the incident, Mike Cuevas testified that Mr. Diaz came to his home and in his attic apartment left his hoodie, and it had Mr. Taylor's watch. And all of these items, Your Honor, had Mr. Diaz's blood located on those. There was none of Mr. Taylor's property found in Mr. Adams' possession. Upon being called to the scene, the officer observed my client walking down the street. He observed that he had blood on his person, and so he immediately stopped him. He placed him in the rear of the cruiser, and there was nothing found on his person that belonged to Mr. Taylor, and this was immediately following the incident. Mr. Torres had indicated, and it was substantiated by his family members, that he ran home. They immediately called 911, and then the police arrived. They were approximately 5 blocks away. And
does it matter? Well, let me ask you this: did the court give a conspiracy instruction?
Your Honor, it was a trial by a 3-judge panel.
That's right.
And there was nothing in the verdict forms that indicated that there was a conspiracy finding of any sort. And there was no discussion throughout the trial that there was a conspiracy theory that had been set forth.
Well, but the facts, as they were testified to, were that at least these two gentlemen got out of the car together and pursued the decedent and were jointly kicking and punching him. So if there's circumstantial evidence, I guess you could say, that your client was patting the pockets, and then whatever presumably was in the pockets ends up in Diaz's possession, doesn't your client face the same culpability as being a joint actor together?
Well, we would argue that that is not correct, Your Honor. Mr. Diaz took off running and approached this individual. Mr. Adams followed. It was at that point in time, a very quick observance by Mr. Torres. He then ran away. There is nothing, the record is silent, and the court may consider what was not proved through State versus Madison, the Ohio Supreme Court. This court can consider what was not proved, and there was no testimony or there's nothing in the record to indicate what happened next.
Well, wasn't there evidence that the decedent's blood was found on your client's shoes?
There was, Your Honor, but that still doesn't go toward a theft offense
No, I
and an
understand.
aggravated
Okay.
robbery. And so we would submit, Your Honor, that, well, also if we could go back to Officer Denman. Officer Denman searched the vehicle and he testified that he found all of these items. And further DNA analysis, although it revealed that Mr. Adams' blood was possibly on a cell phone that was located in the vehicle, our argument is that they were out, they were bloody from hitting the school earlier, but that his DNA was not excluded. So it wasn't exactly, he said that there were three possible DNAs that were on the phone, and it's just a small portion of the back of this phone. And so Mr. Adams' blood was, our argument is that it was just in the car from earlier in that day, because there's no testimony that ever shows that he got back into the vehicle, but instead, all of the other items were found on Mr. Diaz and his property. And one thing that's very important to note, Your Honors.
Well, wait a minute, why would he have to get back into the vehicle? If he reached into his pocket and took his cell phone and transferred blood, your client transferred his blood, he could have just handed it to Diaz and they went their separate ways. His being in the car really is not relevant, right?
Well, not necessarily. And one thing to know, there were two cell phones that were located. One that was located in the yard of a neighbor, and the other one that was located, located in the car. But also of importance is that when Mr. Diaz arrived at Mr. Cuevas' attic apartment, he had told him he was talking about the cell phone. So the only evidence that was ever presented was that of which Mr. Diaz was talking about the cell phone, the same one that was found in his car or his grandfather's car, and the watch. There was no testimony of any property whatsoever on Mr. Clarence Adams' person. There were no statements made by him. There was no testimony that anyone ever saw any property in his possession.
And you have just about 3 minutes remaining to make it. Reserve.
I'll reserve, Your Honor. Thank you.
Good morning, Your Honors. May it please the Court, Mary Solanska on behalf of the appellee in the state of Ohio. I would submit, and as I noted in my brief, the arguments in this case, although the title of the assignment of error may have said manifest weight of the convictions in the plural, the argument is solely focused on the aggravated robbery. And even if the court were to say, okay, there wasn't sufficient evidence of the defendant himself committing the aggravated robbery, felony murder would have to stand because the defendant has not challenged that before the court. I just wanted to bring that to the court's attention. As far as the manifest weight of the evidence, a significant amount of the defendant's brief is centered on challenging Mr. Torres' credibility and his ability to see and hear the things that he testified that he saw and heard. And I would submit to the court that on each point raised by the defendant, Mr. Torres withstood the test of cross-examination, and the panel was in the best position to judge his credibility and to decide whether to believe his testimony or not. And the other thing I wanted to point out is that Mr. Torres' testimony was corroborated by certain pieces of physical evidence at the scene. He testified that the beating started at one house and that the victim ran, and they continued to follow and beat him again as he got further down the street. And there's a trail of evidence, according to Sergeant McCoy, that starts where Mr. Torres said this beating began and travels all the way to where the body was found. And that corroborates Mr. Torres' testimony. The other thing that corroborates his testimony is that the girlfriend, I guess, or friend of the victim where we're staying, Vicky, and I can't recall her last name, testified that when Mr. Taylor left the house that night, he was wearing this coat and that there was nothing wrong with the pockets, they weren't torn, nothing was hanging off. And when the coroner is examining the body and looking at the clothing, he says, hey, not only is there blood all over this coat, but the pocket is torn, which would support a robbery, an aggravated robbery conviction in this case, or it supports the other evidence that Mr. Torres testified to. Because as Mr. Torres said, he saw the defendant, not Mr. Diaz, rifling through or shuffling through the pockets of Mr. Taylor.
Is it clear from Mr. Torres' testimony when that occurred in the timeline? I mean, I know this all sounds like it's happening slowly when you're reading it, but I mean, when was it, when they first came upon him? Because it says he had to bend down to rifle through.
No, it was at some point kind of during the, probably, I don't know that the testimony was very clear, but my understanding of it was after the victim had been knocked to the ground and kind of was sort of incapacitated due to the injuries, because the coroner testified he suffered severe injuries to the head and neck from the beating that he suffered. These two beat the victim to death. So it probably was at the furthest point that Mr. Torres said where the victim's body was found. But he said that he could see the defendant rifling through or shuffling through the pockets. That's consistent with the pocket, one pocket being torn, and that's consistent with the property of the victim being located, although not on Mr. Adams, on Mr. Diaz. There's property in the car, there's property in the hoodie that's left at Mr. Cuevas' house, that's the bloody watch. The cell phone is in the car, and I think I caught in my notes that there was actually, the defendant's blood was on the cell phone that was in Mr. Diaz's car. So I really think it's irrelevant that, I shouldn't say irrelevant, it doesn't support a manifest weight argument. In other words, the evidence is not against manifest weight simply because all the property was found on Mr. Diaz, because you have the defendant shuffling through his pockets and this property found.
Is the testimony of Torres internally consistent regarding how much of the assault he would, the timing of when he fled to go tell somebody to get a phone call, and he's already on the ground at the place where the body was found, and then they're rifling through his pocket?
Yes, his testimony was consistent, and it was consistent with his statement to the police that he witnessed all of those events, because what he said was, they started to beat him and I shouted that they should stop. They hollered at me to shut up. They then chased, the victim got up and started to run. They chased him down the street. Mr. Torres is watching them beat him. He shouts again, you need to stop, and they turn around and holler at him, and he at that point feels very threatened. And it's when he sees the victim on the ground and believes that and he testified, he believes that they had killed him or that this guy was going to die from the beating they'd given him. He says, oh no, and he takes off and he runs through backyards because he doesn't want them to see where he's going. And he's jumping fences. He says he injures himself as he jumps a fence. And when he gets to his cousin's house, who happens to be Veronica is the sister of Mike Cuevas, he's out of breath. He's hysterical. He bursts not just into the house, but right into the bedroom where they're sleeping, and he starts shouting, you know, Mike was back there where Mike had been with us, and, you know, I think they beat this guy to death, and it's all consistent, and it came in as excited utterances, which I think excited utterances to me bear a very great amount of credibility, and I think that the panel was free to assess that credibility factor as well, because you have someone who's just hysterical, and there was abundant evidence that he was just beside himself. He was so upset about having witnessed this man being what he believed was beat to death, and ultimately what did occur in this case. So that corroborates Mr. Torres' testimony. And as far as the fact that, I just wanted to touch on the point that the eyesight of the victim, the record is silent as to whether he had any vision problems. But he was asked about, you know, have you had your eyes checked recently? And unfortunately, the prosecutor didn't follow up and say, do you wear glasses? Do you have any problems seeing anything? But he was not, I want to point out to the court, he was 19 years old at the time of the murder, and he didn't testify that he suffered any problems, and the testimony he's giving is consistent with some of the physical evidence at the scene and in the car. So I would submit that that's really a red herring. There was no testimony that he had any vision problem that would have impaired him. Now the lighting, when you look at the testimony of Sergeant McCoy and of Detective Seibert, they talk about the fact that there's a street light at the house where the beating begins. There's one about halfway in between the house where the victim is found, and there's a street light where the victim is found. Not only that, Sergeant McCoy testified it was a near full moon. They have a whole crime scene van with a big spotlight that they can put up if they're investigating a crime scene at night. And he said, we investigated it totally by the moonlight and the street lights because there was more than enough light for us to see to conduct an investigation, which would corroborate Mr. Torres is saying there were street lights and I could see and I saw what I told you I saw. It wasn't too dark.
Did I read in your brief, or I don't think I imagined this, that one of the officers testified that photographs of the crime scene were taken without flash?
Yes, Sergeant McCoy did testify to that, and that's in the record. I don't have the exact site now, but it is in my brief. You're correct that I did point that out. So I think that when you look at all of this evidence, there's sufficient evidence to support the credibility of Mr. Torres that he saw and heard the things that he testified to, including the robbery. Then you have the circumstantial factor that we see Mr. Torres sees Mr. Adams patting down the victim's pockets. There's a pocket that's torn, and then you have the victim's property in possession of one of the two people that beat him to death. And I think that that's more than sufficient evidence and is not against the manifest weight of the evidence when you look at that, because the panel could look at the circumstantial evidence and say that Mr. Adams was complicit in stealing that property because he's the one that was patting this man down, and then his co-defendant is the one that's found with the property in his car and in the pocket of his hoodie. And as far as the complicity, there wasn't an instruction because obviously it was a 3-judge panel, but you know, the court is presumed, the trier of fact as a judge is presumed to know and apply the law correctly to the facts of the case. And you don't have to, in an indictment, state a complicity charge. You can charge him as either the principal or as a compliciter. So the fact that there wasn't a complicity charge doesn't mean that the court wasn't able to use the circumstantial evidence and say, hey, if you participated in, you know, a great deal of these events, but you didn't have the property on your person, but you were the one going through the pockets, then in the mind of the panel, that evidence supported the conviction of Mr. Adams for both the aggravated robbery and then the felony murder. I believe that the evidence in this case is really overwhelming. There was no substantial question as to Mr. Torres' credibility. He did withstand the test of cross-examination on each of these points, and the panel chose to believe his testimony. And a conviction is not against the manifest weight of the evidence simply because the trier of fact chose to believe a particular witness's testimony. I think that, and the other point regarding Mr. Torres was regarding his alcohol and marijuana consumption. He testified that much earlier in the day he had consumed some marijuana, and he said that he had 2 to 3 shots at the time of the prior to, but there was no testimony directly saying when he had had those shots. It may have been right before, but 2 to 3 shots would not necessarily have impaired him to a point that he couldn't have seen and heard what he testified to. And again, you have that physical evidence corroborating it. And the other thing I wanted to point out is that what else corroborates this is that the defendant's blood is found, or excuse me, the victim's blood is found on the cuff of Mr. Adams' jeans and on his shoes. The BCI forensic scientists testified that they couldn't exclude Mr. Diaz or Mr. Adams' shoes as having made bloody footprints in the scene, at the scene, that they were similar and they could not be excluded as having caused those bloody footprints. And Mr. Adams' blood was found on the victim's cell phone. And I think that's, to me, is a key piece of evidence that shows that he participated in this theft offense, and the trier of fact was free to infer from all of this evidence, the direct and circumstantial evidence, that in fact when Mr. Adams rifled his pockets, he took that cell phone. And that's how his blood, because the officers testified that he had some cuts, got on that cell phone that ended up in Mr. Diaz's car. So at some point between when it was in the victim's pocket and when it was found in the car, Mr. Adams had that phone. He touched that phone, he had it. And that supports the aggravated robbery. I think in this case, the evidence is overwhelming. The trier of fact was in the best position to judge the credibility of the witnesses and obviously chose to believe the state's witnesses. I don't think that there's been anything presented today that would warrant this court exercising that exceptional power and saying that this conviction is against the manifest weight of the evidence, because I believe the evidence shows that it is not. And there's no other questions.
You have 2 minutes.
Thank you, Your Honor. Your Honor, the blood from the cell phone, we would ask the court to consider the fact that Mr. Adams was earlier in the night. It was testified that he punched in the windows of a school, and so his blood could have been in the car, which was where the cell phone was located. Another
Did he take
theory.
the witness stand?
No, Your Honor.
So someone else testified that he was there punching out these windows?
Yes, Mr. Cuevas.
What?
In addition, Your Honor, if there was so much blood that was located on his cuff of his shoe and his shoe, it goes to the conclusion that it's quite possible that when he was involved in this beating, that his blood could have transferred on this person's cell phone, on Mr. Taylor's cell phone. There's no evidence to indicate where the cell phone was located. Furthermore, patting and shuffling would not result in ripping and tearing of pockets. And I would ask the court to consider imagining your own neighborhood and looking 10 houses down in your own neighborhood. And in the middle of the day, it would be difficult to see what exactly Mr. Torres said that he saw. Mr. Taylor's body was located approximately 10 houses down from Mr. Diaz's house and David Ortiz's house, which is right across the street where the vehicle was located. 10 houses down. At 2:30 in the morning, Mr. Torres couldn't possibly have seen what he said that he saw in the middle of the night. In addition, Your Honors, our request for relief would be that the facts would mandate a conclusion here that since no theft occurred, that the aggravated robbery charge must be reversed, and that we're asking the court to find it in favor of the appellant in this matter. Thank you, Your Honors.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement, issue a decision which will be mailed to both sides as well as posted on the Ohio Supreme